Hey everyone, and welcome back for another deep dive. Today, we're taking a trip to Jamaica.
Ooh, Jamaica. Sun, sand, and data privacy.
Well, not exactly the typical vacation, right? We're actually looking at a legal case that really exposes just how complicated data privacy can get, especially in our increasingly digital world.
Yeah, this one's a doozy. It really highlights those tricky gray areas in data protection, especially when you've got multiple companies involved, each with their own interpretations and actions.
Okay, so set the scene for me. What happened in this case?
Right, so the case is called Morrison v. Elephant Group Ltd. Basically, a woman named Morrison had her personal data accessed and shared by her former employers, and she didn't give them permission to do so.
Hold on, they just went ahead and accessed her data without her consent. What was their reasoning?
Well, things get a bit murky here. They tried to justify their actions using exemptions in Jamaica's Data Protection Act, the kind that are usually meant for, courts and law enforcement, not private companies.
So what was their argument? Why did they think they were in the clear?
They were involved in a labor dispute with Morrison at something called the Industrial Disputes Tribunal, and they claimed they needed her data for their defense. Essentially, they try to use what's called the Administration of Justice exemption.
But wait, isn't that exemption specifically for entities that are, actually administering justice, like judges and the police? These are just companies involved in a regular legal dispute.
You got it. That's the problem here, right? This broad interpretation using this exemption when they're not really administering justice, it's a huge red flag. It could open the door for any company to just access people's data by saying, oh, we need it for our legal defense.
That's a scary thought. So did the court accept this argument? Did they buy it?
Sadly, yes.
Yeah.
The court accepted their justification. And that's what makes this case so concerning. It sets a precedent that could weaken data protection for everyone. I mean, imagine a world where any company, just because they're in a lawsuit, could access your data. It's a privacy nightmare.
It really is. It feels like this case has opened up a Pandora's box of potential problems. And to make matters even more complicated, there was another company involved, right? A third party, who also accessed and shared Morrison's data.
You're right, there's another layer to this. A company called Advantage Communications, or AVC, also got their hands on Morrison's data. And they tried to justify their actions using Section 39 of the Data Protection Act.
Okay, and what does Section 39 say? What's that all about?
Well, Section 39 allows for the disclosure of data if it's needed for legal proceedings. But here's the catch. AVC wasn't actually directly involved in the legal battle between Morrison and her former employers.
So they weren't part of the case. So then, what right did they have to share her data? Shouldn't there be some sort of official process, like a court order or something, to access data like that?
Exactly. That's the point. AVC wasn't legally required to share Morrison's information. It's like this, imagine a subpoena is like a formal request slip. A company has to take that slip to a judge and say, hey, we need this person's data for this reason. If the judge says okay, then they can access it. AVC basically skipped that whole process.
So they bypassed the safeguards, essentially. That doesn't sound right at all.
No, it doesn't. And get this, ABC could have obtained the information legally if they really needed it. They just chose to share it voluntarily without being legally obligated to, which raises serious questions about how much they really respect data privacy.
This whole situation makes you wonder if having another perspective, like, say, the information commissioner, could have made a difference. The information commissioner in Jamaica is like a watchdog for data protection.
100%. The Office of the Information Commissioner, or OIC, they're the experts, right? They could have brought so much to the table, like helping the court really understand the ins and outs of the Data Protection Act,
Yeah.
how the exemption should actually be used.
Yeah, it's like when you have a complex medical issue, you want a doctor who specializes in that area to weigh in, right? Maybe the same logic applies here.
Perfect analogy. The OIC's absence in this case, it's a real head-scratcher. Their involvement could have potentially shifted things, offered a stronger defense for Morrison's privacy rights.
Okay, so we've got these questionable exemptions being used, a third party sharing data without a clear legal reason, and a missing expert voice in the form of the information commissioner. This is a mess, but you mentioned something earlier about Morrison's constitutional rights. How do those factor into all of this?
Now this is where things get really interesting. Morrison could have actually built her case on her constitutional right to informational privacy, which exists separately from the Data Protection Act.
So even if the Data Protection Act wasn't on her side, she had another legal avenue she could have explored, like a backup plan.
Exactly. Constitutional rights often hold more weight, and if she'd invoked that right, it could have forced those companies to provide a much stronger justification for accessing her data.
Wow, that's pretty powerful. Do you think the outcome of the case could have been different if she had taken that route?
It's tough to say for sure, but it definitely could have shifted the power dynamics. The companies would have been held to a much higher standard, and the court might have reached a different decision. It adds another layer of complexity to an already complicated case.
It definitely does. And, for our listeners out there, this might seem like a very Jamaica-specific issue, but this case has implications that reach far beyond Jamaica's borders, right?
Absolutely. Many countries have data protection laws with similar exemptions, and the way those exemptions are interpreted, it can have a ripple effect globally. This case is a wake-up call for all of us to pay closer attention to how our data is being used and protected.
It's a reminder that we can't be complacent. We need to be informed, know our rights, and hold companies accountable. Let's take a quick break to process all of this. When we come back, we'll dig even deeper into some of the legal details and explore what this case means for data privacy in the digital age.
This case, it really shows you how interconnected our digital world is. What happens in one country, it can actually set a precedent that impacts data privacy laws and practices globally.
Yeah, it's kind of a sobering thought. So let's unpack some more of this case. One thing that really stuck out to me was how much the defendant companies leaned on that Data Protection Act transition period, almost as if it gave them a free pass to not fully comply.
Ah, yes, the transition period. That's a key point. They tried to argue that because of this grace period, they weren't totally bound by all the parts of the act yet.
But, wouldn't Morrison's constitutional right to privacy still be in effect,
Yeah.
regardless of any transition period?
Exactly. Constitutional rights, they don't just disappear because there's a transition period going on. And this is what makes those constitutional arguments in data privacy cases so powerful. It gives individuals a stronger level of protection.
It's like having a safety net, even if the specific laws are still, I don't know, a bit shaky. But let's talk about the Data Protection Act itself for a moment. Do you think there might be some loopholes or maybe some vague language that led to these kind of questionable interpretations?
You're right. There's definitely room for improvement there. The court's analysis in this case, it seemed to overlook a really crucial element. The whole concept of lawfulness being the foundation for any data processing activity.
Okay, so break that down for me. What does lawfulness really mean in this situation?
Think of it like this. Before a company even starts talking about why they need your data, they have to show they have a lawful reason for accessing or sharing it in the first place.
So it's not just about is it necessary, but is it even legal to begin with?
Exactly. And that's where things get fuzzy with this case. AVC, for instance, they said they had a legitimate interest in sharing Morrison's data because the defendant companies needed it. But that's not enough.
They can't just ride on someone else's justification.
Yeah. Nope, not at all. Every data controller, and remember, AVC was acting as a data controller here. They each have their own individual responsibility to make sure that what they're doing is lawful according to the Data Protection Act.
Okay, so AVC needed their own solid reason for sharing the data and not just, well, our client needs it.
Precisely. They had to show that they had a legal basis to access and share that data, a separate, independent reason from whatever the defendant companies were claiming.
Didn't we talk about how AVC could have gone through that formal legal process, like getting a subpoena, if they really needed the info?
We did, and that's what makes their actions so questionable. They could have gone through the proper channels, but they chose to just hand over the data willingly, which really puts their commitment to data protection principles into question.
It feels like they took a shortcut, and in doing so, they might have sidestepped some important legal safeguards.
Great way to put it. This case really emphasizes how important transparency and accountability are in data privacy. Companies have got to be more careful, follow those proper procedures, even when it might be inconvenient or take more time.
So it's not enough to have these data protection laws, but companies actually have to, respect them, and individuals need to know their rights.
Absolutely. And speaking of knowing your rights, let's circle back to the role of Jamaica's Office of the Information Commissioner.
Okay, what could they have done differently in this case?
Well, picture this. The court, they see how complex this data privacy issue is, and they decide we need an expert. So they call in the Information Commissioner's office, get an impartial opinion on how the Data Protection Act should actually be applied in this specific scenario.
So they're bringing in a neutral third party, someone who really understands data protection law inside and out.
Exactly. Think of it like having a veteran referee for a really important game. Their presence could have brought some much-needed clarity, offered guidance to the court, maybe even resulted in a more balanced judgment.
Feels like a missed opportunity for sure. It makes you wonder, should courts be more proactive in these types of cases, like always bringing in the Data Protection Commissioner's office when data privacy is a core issue?
Now, there's an interesting thought. It would definitely bring more expertise and accountability to the whole process. But even if the courts aren't doing it, companies could always reach out to the Information Commissioner's office on their own, be proactive.
Right, like if you're a company and you're not sure about the data protection implications of something, go to the experts, get some advice before you make a decision.
Precisely. Better to be safe than sorry, especially when you're dealing with sensitive information.
Okay, so we've covered the exemptions, the role of the Information Commissioner, and the potential power of using constitutional arguments.
Hmm.
But before we move on, I want to revisit something we touched on earlier, the difference between data controllers and data processors.
Ah, yes, that's a fundamental distinction in data protection law. It's really key to understand who's who in this whole data game to really grasp the implications of this case.
So remind me again, what's the difference? What makes a company a data controller versus a data processor?
It's like this. The data controller, they're the captain of the ship, right? They decide why and how personal data is collected, used, and shared. They're the ones setting the course.
Okay, they're the ones making the decisions. What about the data processor?
The data processor is more like the crew. They're carrying out specific tasks related to data processing, but they're always working under the captain's orders.
So they're following instructions, but they're still responsible for handling the data properly.
Exactly. They might be doing things like storing the data, analyzing it, maybe even sending out marketing emails, but they're always acting on behalf of that data controller.
Now, how does this all relate back to the Morrison case? Was there some confusion about who was playing what role?
There was. And that lack of clarity, it's a big issue. You had Centerfield, that was Morrison's former employer. Then you had AVC, the third-party company that shared her data. And then there was ANA Services Solutions Consultants, also known as SSC, and they're the ones doing background checks.
Okay, that's a lot of players.
Mm-hmm.
So who was the captain in this scenario, and who is the crew?
Well, Centerfield, they were definitely the data controller here. They're the ones who wanted Morrison's data, decided how it would be used. They set the whole thing in motion.
Okay, that makes sense. But what about AVC? They seem to act pretty independently when they shared the data.
This is where it gets a bit murky. The way they acted suggests that they might have actually been operating as an independent data controller themselves, not just a processor following Centerfield's instructions. They already had Morrison's data from when she worked for them, and then they made the decision to share it, seemingly without even checking with Centerfield.
So they went rogue.
You could say that. And this highlights why it's so important for courts to clearly define those roles when you've got multiple organizations involved. Without that clarity, it's hard to figure out who's really responsible for protecting the data.
What about SSC, the company that was doing the background checks? Were they a controller or a processor?
SSC, they seem to have been acting as a processor in this situation. They were hired by Centerfield to do a specific job, and we can assume they followed Centerfield's instructions while doing it.
So they were like a specialized member of the crew brought in for a particular task.
Good way to put it. Their role was more limited compared to Centerfield in AVC.
This just goes to show how complicated it can get when multiple parties are involved in handling data. It's like a game of telephone, right? The message can get all jumbled up if those roles aren't clearly defined.
Exactly. And that's why we need clear legal frameworks, guidelines that spell out these roles and responsibilities in detail. We need to avoid situations where it's unclear who's ultimately responsible for that data.
Okay, this has truly been a deep dive. We've uncovered some pretty complex stuff, but you've explained it all so clearly. Before we move on to our final takeaways, any last thoughts on this whole data controller versus data processor issue?
Just this. Clarity is key. When companies are upfront about their roles and responsibilities in handling data, it builds trust with individuals and makes it easier to hold everyone accountable. Everyone wins.
Love it. Transparency and accountability, those are definitely words to live by in the digital age. Let's take a moment to gather our thoughts, and then we'll wrap up this deep dive with some key takeaways and some food for thought for our listeners.
And we're back, folks. We've been digging deep into this Jamaican legal case, Morrison v. Elephant Group Ltd., and it's really made me realize just how vulnerable our data can be, even when we think it's protected by laws.
Yeah, it's definitely a wake-up call. This case shows us that it's not enough to just have data protection laws written down somewhere. They need to be put into practice properly, and courts need to interpret them in a way that truly protects people's privacy. So, big picture time. What are some of the key takeaways from all of this? especially for our listeners who are trying to keep their own data safe in this crazy digital world?
Well, I think the most important thing this case shows us is that courts need to be a lot stricter when they're deciding if those exemptions in data protection laws can be used. Those exemptions, like the administration of justice one we talked about, they should only be used in very specific situations, only when they're absolutely necessary.
Kind of like those break-in case of emergency boxes, right?
Yeah,
You don't want people smashing the glass every time they have a little problem.
perfect analogy. And that brings us to another really important point, clarity. The court in this case didn't clearly define the roles of each company involved. Were they data controllers or data processors? That lack of clarity caused a lot of confusion and maybe even weakened the protection of Morrison's privacy.
It's like trying to follow a recipe where they forgot to list some of the ingredients. You're probably not going to end up with the dish you were hoping for.
Exactly. And while we're talking about things that are missing, this case really highlights how important it is to have a strong and independent voice for data protection, like the Information Commissioner. The fact that they weren't involved in this case, that was a big missed opportunity.
Yeah, it's like having a watchdog that's fallen asleep on the job.
Yeah.
Not very reassuring.
Not at all. We need those watchdogs to be awake and paying attention, making sure those data protection laws are being followed.
Okay, so we need stricter rules about when those exemptions can be used, clearer definitions of who's doing what, and a watchdog that's actually watching. Anything else? What can our listeners do to protect their own data?
This case is a good reminder that we can't just sit back and assume our data is being taken care of. We need to be proactive, stay informed, and be ready to stand up for our rights.
So what did that look like in real life?
First, know your rights. Take some time to understand your country's data protection laws, what they actually say about your data. Then don't be afraid to ask questions. If a company wants your data, ask them why they need it, what they're going to do with it, who they're going to share it with. And if you think your rights have been violated, report it. Don't hesitate to file a complaint with your country's data protection authority.
So it's all about being empowered, taking charge of our own data.
Absolutely. Our data is valuable and we need to treat it that way, just like we would with any other valuable thing we own.
Well said. This whole case has been a real eye-opener, and I think it's safe to say that data privacy is not something we can just ignore. It's always changing, and we need to stay informed and be careful to protect our rights in this digital world.
I agree. Data privacy is everyone's responsibility, and it's by working together, by being aware and taking action, that we can create a safer and more secure online world for everyone.
And on that note, we'll wrap up this deep dive into the sometimes murky world of data privacy. We hope you learned something new today and that you feel more confident about taking control of your own data. Until next time, stay curious, stay informed, and stay safe online.